You're watching FJTN, the Federal Judicial Television Network.
Hello, I'm Bob Fagan. Welcome to our program. On April 20th, the President signed the Bankruptcy Abuse Prevention and Consumer Protection Act of 2005. Most of the provisions take effect 180 days after passage. That means October. Today, it's not our purpose to revisit the merits of the Act or its history. Instead, we want to focus on what's being done now and what's planned for the future in order to comply with the requirements of the Act, both through national and local initiatives. This program is part of a greater effort to ensure that you get the information you need. It's just one step. By the end of our broadcast, we hope you'll be more aware of initiatives already taken at the national level in response to the Act, what incentives are required at the local level, what's been done already at the local level, and where to access additional information. Okay, let's take a brief walk through our agenda. First, in a pre-recorded interview, Glenn Pahlman, Chief of the Bankruptcy Court Administration Division, and Frank Zabak, Chief of the Bankruptcy Judges Division, will provide an overview of changes and impacts of the Act. This will be followed by 3 live in-studio panels. Panel 1 will discuss initiatives being taken at the national level, including what's happening with the Bankruptcy Rules Committee, revised forms, and what to expect. Panel 2 will focus on CMECF-related initiatives, dealing with software, dictionaries, and a schedule of events. Then our final panel will cover local initiatives to include topics like educating staff in the bar, local rules, means testing, and so forth. We'll wrap up with questions and comments, then some advice about where to find additional information. Throughout the broadcast, you'll see numbers you can call or fax to ask questions of our panelists. We'll also refer to information provided in the downloadable materials. Okay, let's get started. The other day I spoke with Glenn Pahlman and Frank Zabak regarding the impact of the Act. Let's take a look. First of all, Glenn and Frank, thanks for joining me today as part of this discussion.
You're welcome.
A lot of things happening. We know that, a lot of changes taking place. Glenn, I want to start with you. What are some of the major changes and impacts that clerks need to know about now?
Well, of course, the new law was passed April 20th, but it had been pending on the Hill for a long time. And so the clerks of court have, over the years, have had a lot of opportunity to analyze the legislation and now the law. The most significant impact, though, is perhaps in the means testing area. The means test is required in every Chapter 7 case, and in most bankruptcy courts, Chapter 7 cases dominate their filing levels, so that would be a very significant issue. Right. That change will require the CMECF, their case management system, to be adjusted. They'll have to adjust their local court procedures. They'll have to make changes to forms and rules. Other changes as a result of the legislation impact are additional noticing requirements. There will no doubt be additional hearings. There's informal pauperis provisions. So the overall effect of the legislation is, can be quite significant and will impact court administration generally. The other thing that could happen from the legislation is its impact on case filing levels generally. As I mentioned, Chapter 7 cases dominate most bankruptcy courts now. We could have a significant change in case filing levels, and we could have a significant change in the case filing mix, the number of Chapter 7 cases vis-a-vis the number of Chapter 13 cases. But overall, the bankruptcy courts, I think, will clearly spend the summer months getting prepared for the effective date in October, and I think we'll do quite well.
What about for the BAs, Frank? Let me turn to you now. They have some major tasks ahead of them.
They do that, and what Glenn said about having years to prepare, the BAs have also been in that position, so they were prepared for a number of things to happen. The BA districts are very heavily loaded towards Chapter 13s today, so the intent of the law that more people file a Chapter 7 as opposed to a 13 will not be as pronounced, I think, in these 6 judicial districts. In terms of major changes, I think the biggest change will be the additional responsibilities the BAs will have. Everything from certifying consumer credit counseling firms. They will be responsible for maintaining a list and sort of qualifying them. Yeah. And our big problem there is to determine just how comprehensive the program has to be. Will it have to be a face-to-face? Can you do it over the internet, which is available today? Can you do it by telephone? That's a large question to be answered. Debtors will also be required to take financial training. And there again, we'll have to determine what the parameters of that is. Another major responsibility will probably be their policing of bankruptcy petition preparers. Everything from qualifications to, believe it or not, the Judicial Conference has to set the fee to be paid by bankruptcy petition preparers. But I think as we Glenn said, we're working through the summer. There's a lot going on behind the scenes, and we'll be ready. I
think that's what's important for people to know about. I mean, this is time one, and this is a growing process, and that's what's key. And what we're trying to do is give the information that we know is happening right now. Again, a lot happening, and Glenn, let me go back to you. What's being done now as we speak, and what should folks be prepared? I know you have working groups that are in order and so forth. You may want to talk about that.
Let me speak about 2 working groups that we have, and one is a long-standing CMECF working group that's headed up by, chaired by Dana McWay, bankruptcy clerk in Missouri Eastern. That group, staffed by Robbie Robinson and others of my office, we've been working very closely with them. They're analyzing the legislation and identifying what changes need to be made to CMECF to comply with the new law. And so there's a tremendous amount of energy and effort being devoted to that. Very shortly, the application will go to testing, and the timeline or the goal is to get this new software, a dot release known as 2.7, to the bankruptcy courts in early September. We want to get to the courts in early September so that they have ample time to test it and make local adjustments so they're ready to go on October 17th. So that's the CMECF effort. Separately from that, the director has established a bankruptcy legislation working group. And this is a working group that consists of 11 people. We've got 5 clerks of court, 3 bankruptcy judges, and 3 deputy clerks. This group has met. They met just last week. We had a very, very good meeting. And their purpose is to identify the tasks that need to be performed by the bankruptcy court, particularly the bankruptcy clerk's office, to comply with the legislation, but also to identify how best to do that work. The timeline there is a very aggressive timeline, actually, is to try to get a product out to the bankruptcy clerks before the July 4th weekend. And the reason we're being so aggressive is that so that we can get the information out to the court so that their local decision making can really be informed by this information and this material. Yeah. So that's the general plan.
And that's vital information.
Absolutely.
Before they start to move in certain directions, it's vital information.
It'll be a resource. It'll be a reference. Sure. Obviously the courts themselves are already starting this analysis, but we think we'll get it to them early enough that they can at least utilize it to a great degree.
Right. Frank? BAs.
There's a great deal going on here at the administrative office. The director has appointed my boss, Assistant Director Peter McCabe, to head a working group. And we meet 3 times a month. And everybody in the building who has anything to do with the act, from finance to space and facilities to clerks to judges to BAs, gets together and addresses all of the issues. The last time we looked at our working paper, we have sort of a matrix of all the tasks to be done. It was in excess of 40 pages.
Wow.
And it grows every week. In terms of activity at the conference level, the Bankruptcy Committee of the conference has established a subcommittee to implement the Reform Act, and they are going to review everything that needs to be done and make sure that we do it, or the responsible person does do it. In terms of the Bankruptcy Rules Committee, there's an enormous amount of activity, an enormous number of additional meetings being held. They formed 3 separate subcommittees, one for consumer issues, one for business issues, and one for forms. The plan is to publish interim rules. The normal rules process takes 3 years to complete from start to finish. The plan is to provide interim rules so that local jurisdictions can adopt them until the rules process can finish. The same with forms. The plan is to get the rules and the forms out by July, not only for the benefit of the court, but also for the benefit of the software companies that have the forms published and be ready for the effective date in October.
Right. I mean, a tremendous amount of work to do.
There is.
One other question. If you were to give advice to clerks and BAs, what would you say to them now?
Well, you know, the bankruptcy clerks, we also often talk about the bankruptcy clerk community. And a lot of bankruptcy clerks have done some wonderful analysis and some wonderful research and study of the new law. And so as on other initiatives, I would really encourage bankruptcy clerks to really engage their colleagues. There's a wealth of knowledge and information out there, and I think with the 90 of them working together, clearly a lot can be accomplished and a lot can be gained. Other resources that would be available to the bankruptcy clerk community would include the Federal Judicial Center's website, the administrative office's websites regarding the legislation. The NCBC, the National Conference of Bankruptcy Clerks, is having its meeting in early July in Chicago, and I know they have a panel discussion on the legislation. In August, working together, your agency and the administrative office are having the operations forum, another opportunity really to gain familiarity with the new law and its provisions and what bankruptcy courts across the country are doing. So lots of resources, lots of opportunities. And certainly the clerks should be sure to engage their own deputy clerks and their judges and make sure that court is extremely coordinated and has a timeline for moving forward.
That's great. Frank, I'm going to give you the last word.
The BAs are a very small community and over the years have been very close-knit and share information, share money, and I think we'll be more than prepared when the time comes. We are trying to find funding for a seminar for them alone to get together to prepare for the act, and when the time comes, we're ready to fly.
We'll be prepared.
And as a word of closing, I'm one of the old timers who lived through the marathon, and we all thought it was the end of the world. It's not, and this won't be.
Yeah. Thank you, folks, for joining me.
Thank you.
You're welcome.
Yeah.
Thank you.
Lots of good information there, I'm sure you'll agree. Now let's turn to our first panel. Joining us here are Jim Wanamaker, Attorney Advisor, Bankruptcy Judges Division at the AO, Jim Walden, Clerk of the Bankruptcy Court from New Jersey, Mary Louise Mitterhoff, Attorney Advisor from BCAD, and Mary Fritchie, Attorney Advisor also from BCAD. Welcome to all of you. Jim Wanamaker, let's start with you. Tell us about what the Rules Committee is doing vis-a-vis the Act and what's hot.
Well, Bob, it's been really hectic lately for the Rules Committee, as it has been for so many other people. The 3 subcommittees that Frank mentioned, the forms, the consumer, and the business subcommittees, they've been meeting almost weekly since before enactment of the bill. They're also getting help from 3 other subcommittees, the Technology Subcommittee, the Cross-Border Insolvency, and the Appeals Subcommittee. That's all leading up to 3 days of subcommittee meetings in Boston next week, followed by the first week of August, the full Bankruptcy Rules Committee meeting then, and then consideration, hopefully within a few weeks of that, by the Standing Rules Committee and by the Judicial Conference. The goal is to get suggested interim rules and forms to the courts for adoption later in the month of August, and that way giving the courts plenty of time to prepare for the general effective date on October 17th.
Well, what about the normal rules-making process, and how is that, what's so different about this?
Well, the normal rules-making process is at least 3 years, and with something as complicated as this bankruptcy bill, it could stretch considerably longer. Because that's too long, the approach this time is to come up with a recommendation from the Judicial Conference, hopefully for suggested interim rules that the courts could adopt on a more expedited basis. There are a lot of unanswered questions right now, but I hope we'll have more detailed information and guidance after these subcommittee meetings in the next few weeks.
Great, thanks. So the big thing is October. That's the big date. So let me turn to you, Jim. Now, you also serve as the Clerks Representative to the Rules Committee. Tell us a little bit about what specific rules are likely to have some of the biggest impact.
Well, specific? That's a little tough. First thing I want to say is the people at the table here today, I just want to give them a little bit of credit for all the work that's been done. Our two Marys and Jim are working, unfortunately, around the clock, and as good as they look today, they're really exhausted. I mean, I think that they have really, really worked hard. Now, as far as the Rules Committee is concerned, the good news, of course, is that what they're trying to do is make sure that the clerk's office is not as burdened by all of the things about the rules that they were, initially when they read the act and they saw how large it was, that they were going to have to do. So instead, what they've done is they have looked at every single situation and kept in mind the fact that clerks already have enough to do, and they're trying to minimize. And for instance, one of the things that we're talking about specifically would be the means test. And the means test is something that raises fear in everybody's heart for some reason. But it really is not going to be that bad, certainly not that bad for us. Maybe for the debtors it's certainly a challenge, but for us it won't be so bad because we're going to really rely on what they provide us as opposed to try and make some kind of determination one way or another. And the Rules Committee has, again, just to reiterate what Jim said, none of this is final, of course, and they will meet in Boston. Hopefully some of those things will be finalized at that point. But what we will end up with, at least we assume what we'll end up with, is a means test that comes in basically on a form. It's something that's just going to be a check-off, go one way or another, whether or not there's a presumption of abuse. And then we will rely on our automation to generate notices and do the things that we normally do.
Yeah, that's probably a big relief to a lot of clerks who hasn't been really defined.
It was a huge relief, and I think even in discussions as it developed, people weren't sure how it was going to turn out, but the more we talked about it, that's the way it turned out. As far as other rules and forms, we could be here all day to talk about the number of rules that are being changed and the forms that are being changed. One other credit goes to Pat Ketchum. Everybody knows Pat Ketchum, who is consulting back to the Administrative Office and the Rules Committee. Pat has been working on the forms, and we'll have a great product when she's done with them.
That's great. Mary, let me turn to you, Mary Louise. Let me turn to you. Both Glenn and Jim just mentioned some of the working groups. You've been very active, the working groups. What are some of the items that are being discussed at the working groups that are of special interest to clerks?
Bob, let me address the Bankruptcy Reform Working Group specifically. As Glenn mentioned, appointed recently by the director. The first task of that group is to identify new requirements imposed by the bill and to create procedures to address those requirements. In that regard, I'd like to echo Jim's comments that the group is very mindful of trying to ensure that the procedures are the least burdensome on clerks' offices. So in that regard, we are relying heavily on CMECF. Some of the big things that the group addressed, obviously means testing. Mary will go into that a little more in detail later. The credit counseling financial management requirements, as you know, prior to filing, the debtors have to go through a credit counseling session, and prior to discharge, they have to go through the financial management session. So we're trying to work that out so that it can be handled through CMECF, so that the debtor just has to report whether or not they've completed it, or whether there are exigent circumstances that would excuse them or extend the time, and that will be reflected in CMECF. A new requirement is that in particular cases, debtor tenants can deposit lease payments with the court. This is not a typical procedure in court, so the group worked very hard to map out the process. The statute itself is quite complicated, so just sort of going through each of the steps, and that will be one of the procedures that the group sends out to the courts. The next thing is, the next big area was tax returns, another new requirement. In certain cases, upon request, the debtors will be required to provide a tax return for the years during which the case is pending. And the director of the administrative office is specifically required to come up with procedures to protect the privacy of individuals with regard to the information.
And that was a big issue that folks were concerned about, the privacy of the tax
exactly,
returns,
because
yeah.
there is quite a lot of information on tax returns. Obviously, the Judicial Conference policy on privacy will really inform whatever procedures are developed, but really 3 important things to remember. One, that we are anticipating that the tax returns will be filed electronically, not in paper, which is a big relief, I think. Yeah. 2, that parties and not the courts will be required to redact any personal information such as social security numbers or account numbers. And 3, that the universe of people that will be able to access these will be limited, and the group is working on coming up with the appropriate group of people, and that will of course be incorporated into the director's procedures. Another thing that the group talked a lot about was Chapter 15, which is a new chapter of the Bankruptcy Code, which covers cross-border insolvencies. It used to be handled under Section 304 of the Code, and that is also has lots of new requirements, requesting a petition to be recognized as a foreign representative, and the group did a great job of mapping that out as well. In that area, we've sent some informally, sent some of our questions to the Rules Committee to see if at some point they might be able to address some of those issues in rules and/or forms. And then, of course, we talked about the direct appeals provision, whereby a party can sort of skip the second level, or the first level of appeal, really, and go directly to the Court of Appeals. And again, that statute is quite complicated, so just mapping out the process, I think, will be a help to courts. And again, we went through that to identify places where rules and forms might be helpful. In fact, the statute itself does specify that there should be national rules developed, and in the interim, they identified some appellate rules. So I think all of this information will be really helpful to the court community.
We probably have people writing feverishly right
well, hopefully they need not do that, because they can access the information on the Bankruptcy Court Administration Division's website. We have a special link for bankruptcy reform, and all of this information will be posted there.
That's great, and we're going to be posting that website pretty quickly, I think. It may be going up now or afterwards, but we're going to be posting that website so folks can get that information that you provided. Thank you. Mary Fritchie, we're hearing means testing, means testing, means testing. Right. Give us a few comments. What's being done now in this vital area, means testing, and also in forma pauperis?
Okay. Well, the means test, we have been, as Mary Louise mentioned, we have been trying to map out the procedures, and we really do want to make sure there's no burden, or not additional burden on the clerk's office. The means test, there'll be a new form for the means test that'll be calculated by the debtor or the debtor's attorney. That should be filed with the petition. There'll be a checkbox whether or not there's a presumption of abuse. If the debtor's attorney checks that there is a presumption of abuse, then CMECF will pick that up, and then that will generate the notice for the presumption of abuse that's required by the clerk's office.
That's great.
Yes.
What about were you going to say something, Jim?
I think that one of the things that may be coming out of the Forms Committee too is to see if there's a way to at least incorporate some of the information from the means test into the petition, so that when it's filed, the clerk's office is going to be able to process it more easily. Right. But there is going to be a separate document because it has to show the calculations as far as the means test is concerned.
But the clerk's office is going to have no responsibility as far as checking over the calculation or getting out the calculator.
A lot of folks are applauding as we speak right now. A little bit about informa pauperis.
As far as IFP, we do have a committee here at the administrative office working on IFP. We're really fortunate in that the FJC did the IFP study, I think it was back in 1998, looking at the 6 pilot districts, because we have a lot of good information as far as forms, what the judges did, what the clerk's offices did. So we're getting that all together and trying to develop the procedures from there.
That's great. We just have a few more minutes, so let's just end with one question. And Mary, I'm going to start with you. What should clerks be doing this summer as they prepare?
Well, I think besides familiarizing themselves with what the law says, what's been really helpful for us is that clerks are identifying a lot of areas where we need to look into things further and determine what's to be done. So that's great help, and we really hope the emails and the phone calls keep coming.
Great.
Okay.
Thank you. Jim.
Nice long vacation.
Oh, I wish.
You know, I think just the same. What's been happening, and we get phone calls, I think everybody, how many phone calls do we get every day from different sources? Just people are reading the bill, they're looking at the rules, they're coming up with new concept, new ideas. Because the bill is so big, it's amazing. All of a sudden there'll be something that no one thought of before. So, I mean, I encourage everybody to continue doing that.
Mary Louise.
Yeah, I think that from our perspective, the courts are doing a great job of getting prepared. You know, on the national initiatives front, you know, they should stay aware of CMECF changes, 2.7, the documents that come out of the Bankruptcy Reform Working Group, and of course, and probably most importantly, the rules and forms. And then once you know, we have a good handle on the national initiatives, just be prepared to implement you know, whatever local changes they need to in their own courts.
Yeah. Jim, want to make it the last word?
Well, check the BCAD webpage. There'll be additional information on the BJD webpage on the JNet, and just stay tuned. I hope we'll have more definite guidance from the Rules Committee by probably early July, and then the actual draft suggested rules and forms by August.
Yeah. So there's a lot of activity and a lot to follow. Well, that finishes our first discussion. I want to thank all of you. Now we're going to bring in our next panel. We'll play a little walking music for you, and while you're waiting, you might want to think about any questions you'd like to call in or fax. See you again in a few minutes. Welcome back. In our second panel, we'll continue with national initiatives, but here the focus is on CMECF. We'll examine three main areas: software, dictionary, and the schedule of events, when all of this will be rolled out. Our panel members are Robbie Robinson, BCAD's CMECF Product Manager and the lead staff support for the CMECF Working Group. Hello, Robbie.
Hey, Bob.
Kate Stevens, the Bankruptcy Training Specialist, all the way from SDSD in San Antonio. Kate, are you there?
Yes, I am.
Welcome.
Hello.
And here with me is Dana McWay, Clerk of the Bankruptcy Court from Missouri Eastern, and Chair of the CMECF Working Group. Welcome, Dana.
Thank you.
Dana, let's start with you. I know the working group has fleshed out CMECF a content list and
That's
a
right.
wish list. Tell us all about it.
Well, we have been working very hard since April when the new bill was signed. And one of the things that we've had to focus on is what can we do in the time frame that we have available. So among our first issues was what choices should we make? And we looked at the fact that we have a 6-month implementation of the bill, but in software development terms, we really only had about 4 months with which we could work. So we decided to look at it from two angles. One, what are the software production type changes we have to make? and what are things that need to be done or accomplished through a dictionary event. So we made choices based on that, looking at all of the angles in the Act. Let me give you a couple examples. We have put some effort into identifying dictionary events for the means test, but we're also actively pursuing whether we can automate the means test as part of the software changes to CMECF. Another example would be our work that we are doing on tax filings. We had a suggestion offered, which is very good, but it's just not realistic for us to get done in the time frame we have, and that was to have some type of interaction with the IRS so that we could receive those tax filings electronically from the IRS to the court. And perhaps down the road that's a viable option, but it just isn't today. Yeah. I would suggest, though, that people who are interested in what's going on in CMECF take a moment to look at the CMECF working group homepage, and on that homepage they're going to find the version 2.7 task list. And they ought to take a few moments to look at that, get themselves familiar with it. If they have any questions or comments, of course, please bring them to the CMECF working group members. What you'll find on the homepage when you look are design documents, requirements documents, those sorts of things that we're working from. So if a person wanted to look and had something that they wanted to point out that perhaps is of value that maybe we didn't even know, this is the time. We need to get that feedback.
And that's great information. It's a great source of sharing information, but it's great information for them to have because they may in fact see something
if with all of the eyes that have looked at it so far, it's really amazing how many things we find even after all of that.
Sure.
Well, let me just tell you a couple examples of what's on the task list.
Great, great.
What we have done is we focused in on certain items that we know for sure need to be handled through software changes. One of those is forma pauperis. We're looking at the functionality and the process and how we can do that. We have a number of notices that are going to come out of CMECF by the clerk, and so we are looking at how to do that. One of the important points that we've looked at is the fact that in the near future in December, there is going to be a federal rule that comes effective, and that rule allows the party who is receiving the notice of electronic filing to receive that only without the B&C notice. And so we've decided to incorporate part of 2.7 to accommodate that rule change. And in the meantime, we made that even more robust by making a few of EMR changes so that the notice of electronic filing works well.
That's great.
We have a few other things that we're doing. We're looking at the ombudsmans, and we're making professional role types, making it so that parties can be seen on a professional fees report, for example, whether they're consumer privacy ombudsman or the healthcare ombudsman. We're looking at Chapter 15, as Mary Louise said, and what are those foreign proceedings going to look like in the CMECF world. We have a whole bunch of things that we're trying to figure out very quickly, and we hope to be able to do in time. But we're looking at the preferred creditor addresses and how that process will work with the B&C, what we'll do with the case exceptions to that. You know, we are looking at what we call restricted access events. Those are events that are things that parties in the PACER world can't see, but people who are case participants might be able to see. So that is a sample of what we have on the task list.
That's quite a bit.
Yes, it is. It's a lot of work to do.
Thanks, Dana. I hear there are also changes to the all-important dictionary. Robbie, would you like to comment on that?
Sure, Bob, that's right. As Dana pointed out, the working group analysis of the Act has led us to a short list of software tasks to be included in version 2.7. But we're also putting together a long list of new dictionary events and procedures. So we've been working with the SDSD training branch staff to prepare this list of dictionary starter events so that courts will not have to reinvent the wheel. The starter list is under construction. It's being discussed with the CMECF group, the Reform Act working group that Mary Louise talked about. And so a draft of this starter dictionary list will be posted to the working group page, we hope by the end of this month, end of June. I think you have a graphic with the page address for the working group page,
Yeah,
Bob.
let's put that up on the screen. I think it's up there now. Hopefully you can make a note of it while I ask Kate to describe the top 2 or 3 dictionary events. Kate, you're on.
I'd be happy to, Bob.
Thanks.
There are 3 areas that I'd like to touch on that have already been discussed. In response to the debtor's mean test form, that's a new event. And when an event like this is docketed, of course, we will respond by having automatic noticing and flags set up so that things can be tracked for the debtor's status. And then the U.S. trustee will also have to make an entry regarding their findings for the means test after the 341 meeting. So they have designed some text documents that they'll be filing along with a notice. For instance, the U.S. Trustee's statement and notice of presumed abuse. Now, if they determine that abuse is evident, then we will set a 707B flag, which will make those cases prevalent for dismissal as well as preventing automatic discharge. Secondly, Mary Louise was talking about the credit counseling. So we are creating events for certification of credit counseling, motion in order to extend time for credit counseling, a debtor repayment plan, motion in order for exemption from credit counseling. And then, because, as Mary Louise mentioned, each debtor is going to have to complete that financial management course, we have an event that we will be tracking the requirements for called the Debtor Education Certificate. And of course, we don't want to discharge anyone that has not filed that. And then finally, regarding the informa pauperis applications, we have created the application, and then with the order, there's going to be conditional logic so that the screens won't even appear if that motion is granted. So the dictionary is really a lot more powerful now, and we plan to use the advanced features as much as we can to streamline the process and yet capture all the information, especially with your new deadlines.
Thanks so much, Kate. I'm sure folks are looking forward to those changes. Robbie, can you give us some idea of the distribution date of 2.7 given the implementation requirements of the new law?
Sure. CMECF version 2.7 for Solaris and Linux is estimated to be distributed in early September 2005. So this plan allows the courts just enough time to locally test and implement the software by the October 17, 2005 effective date of the Act. So but the schedule is complicated by the requirement to include the new forms and changes to forms, notices that the Bankruptcy Rules Committee is working on, but do not yet exist, that we've heard about from Jim Waldron and Jim Wanamaker. So the planned creditor preferred address process at the BNC, I think Dana mentioned that briefly, that currently doesn't exist yet, so we can't test that yet. But for the most part, the provisions of the Act become effective 6 months after enactment, or that October 17th date. But the law's new statistical gathering requirements become effective 18 months after enactment. And therefore, we're going to address those changes in Release 3.1.
So, Robbie, what's the shelf life for version 2.7?
Well, not very long, Bob. The next CMECF software release will be Release 3. We had to stop work on Release 3 when the law passed and work had to begin on 2.7. But Release 3 was fairly complete as far as programming and testing had begun. Release 3 will be deployed as Solaris and Linux, but this time not as one product but separately, with the Solaris version coming out first, and it's now scheduled for January 2006. Release 3 is a major upgrade that contains software corrections, enhancements. Over 100 various EMRs and MRs are included. A couple major things are a new quality control editor for examining, editing documents and case information. This is going to make it much easier and quicker to make the corrections and using the editor. There will also be a new calendar button for judges' rulings. So this will provide the ability to process matters, schedule for hearings directly from the calendar screen by simply selecting a button indicating the disposition of the matter selected. This is really similar to the Case Trustee 341 meeting disposition screen that the trustees use. Another area I want to mention is the claims management enhancements. There'll be a claims register will be enhanced to display the history of the claim, showing the claim actions and including transfers and objections, as well as history of the creditor. And then large creditors will be able to file electronically in batch claims and claims transfers. So this will take a lot of the scanning work away for dealing and docketing claims. a matrix listing all the tasks, all the MRs associated with Release 3 requirements, design documents, all the information on Release 3 is on that working group page we keep talking about. The plan is for most courts to upgrade to Release 3 on the Solaris platform and then convert to the Linux Release 3, which is the same functionality as part of the Linux implementation waves later in 2006.
Robbie, do I dare ask you about Release 3.1?
Well, in late summer 2006, that's when the statistical changes required by the Act, and we also are looking at possible including changes that the Judicial Conference Bankruptcy Committee would like to have included in the statistical area in that Release 3.1. There'll be no plans at this point for a Solaris version of 3.1. A waiver from the Reform Act statistical reporting requirements will be made for those courts in the last Linux implementation wave that are not yet live on Linux 3.1 by the October 2006 Act statistical reporting begin date.
Dana, let me turn to you. Do you have additional information that clerks need to be aware of?
Yes, I do. I would like to make sure that clerks know that we are going to be having a CMECF Operational Practices Forum. This is sponsored by the Administrative Office and the Federal Judicial Center, and it will be held in August the 18th and 19th of 2005 here in Washington, D.C. As we've done in the past 3 sessions, we're going to take time to look at CMECF operational practices and procedures, and we'll spend time looking at that. Those discussions will be scribed and posted on the JNet. People will have a chance to download them and learn from them. We also know that there are not really possible for everybody in the nation to come to an operational practices forum. So we're trying to set up something so that others can participate remotely. And Robbie might be able to tell us a little more about that.
Robbie?
Sure. The Operations Forum on August 18th, as Dana just said, will be available to all the courts through these presentations. So we're going to have one on the Reform Act presentation. We'll be able to give updated information that we have today. And then we'll have a demonstration of selected CMECF Release 3 modules. And we'll be using WebEx so people will be able to see on their screens at their courts some of the new screens and features that we touched on with Release 3. So later this summer, we'll get to the details about how to join these presentations, listen in, probably be more of a teleconference on the Reform Act, and how to get the WebEx portion of the Release 3 demonstration. So we'll get that out this summer. The operational forum attendance is limited, as Dana said, but we're hoping one person from each court will register, and just want to remind everyone the registration closes next week on June 15th. And we're almost sold out now.
Thanks, Robbie. I think we're ready now to move on to our next panel on local initiatives. Dana, I'd like to ask you to stay and help out. And Robbie, can you stay with us as well?
Be glad to.
Great. Kate, let me thank you so much for your comments.
It was my pleasure.
Great. We'll be back in a few minutes. We want to encourage you to call in or fax in your questions to us. We'll see you in a few. We're back, and we're joined by 3 new panel members. Susan Thurston, Clerk of the Bankruptcy Court, Rhode Island, Sean McAvoy, Clerk of the Bankruptcy Court from the Northern District of Iowa, and Val Early, Bankruptcy Administrator from the Northern District of Alabama. welcome to you all. Susan, let's start with you. Regarding local procedures, what specifically is being done in your district?
Thanks, Bob. There's a number of things we've just started doing, and I would suggest it would work for many of the other courts out there. The first thing, obviously, that many of the panelists have already touched on is just to become familiar with the requirements of the Act and also the national solutions that have started to be developed. We've already heard about some of them today. There are a number of resources available to do that. The ABI website has a tremendous amount of material on the Act itself and some summaries that have been done. There's some colleagues' summaries on the Operations Exchange as well. The various working groups that we've heard about today will start issuing their minutes, and those are being posted on the Bankruptcy Court Administration website, and the Operations Exchange, as I mentioned, will be touching on that as well. So that a number of things to stay attuned with, and that will help facilitate what then you need to do locally once you can kind of understand the national aspect. Secondly, I would recommend, and what we've started to do, is create a local committee to implement the legislation in our court. We took a cross-section of people from various aspects of the court, from chambers, management, operations, dictionary staff, even within your operations, some intake staff perhaps to help with the new filing requirements. So have a committee, and you may even use some subcommittees then to piece out the specific various requirements to be able to start making decisions and making the changes in your forms and rules that you need to do to be ready for October 17th.
Very important.
Right. Another thing that we just did recently to kind of conceptualize and get ourselves organized in understanding what we need to do locally was to create a project plan or a spreadsheet type document to organize the various pieces of information that are flowing to us. The document we created was a spreadsheet type document, but similar to what we used for the CMECF implementation, which was done in Microsoft Project, we found that the spreadsheet worked a little better for us, and we set it up so that the requirement is listed and then what's being done nationally for the events, the noticing the forms, and then that will feed into what you need to do locally. If there's a deficiency process you need to put in place to address the national event or the national form that might be missing, that will kind of help you make sure that you're not going to miss something or be surprised in October. So that's a good way to just organize the information. Another suggestion would be to consider preparing or issuing an administrative general order document with all of your procedures that will be changed, your local forms, your local rules, and by doing it by an AGO type document, which a lot of us did with CMECF also, it allows you some time to test out those procedures before you finalize them into local rules. And with the time frame we're looking at, and not having the federal rule changes till possibly August, there's not going to be a lot of time to have a full local rule revision. So that's another way to organize the information. It can then be used as a training resource for your external filers as well as your internal staff. And then finally, just making some local decisions on the procedures.
Yeah, but two things. I mean,
Yeah.
it's time to get going, and also maybe these general orders are the way to go until these
I think it's a little easier because we're not going to have the information, as we've heard from some of the panelists today, until maybe later this summer, and there won't be enough time. So it's just a different way to handle it.
Tell us a little more about the form, because I think that's kind of interesting, the approach you're taking.
The form that we developed, which again, as I said, you could do it in a spreadsheet format or in any other kind of application, but for us it was just to identify as the information is being given to us, as we start to get memos from the working group, from the CMECF 2.7, from the Rules Committee, put in, okay, what is going to be the national form for means testing? What is going to be the event that goes with that? And then what do we need to do locally to assist that? If there is a deficiency, what will be the form that we need to change locally? What is our current local rule that we need to modify? And is there any other instructions or training associated with that? So it just kind of helps give you a roadmap from what is being done to where do we need to be working.
It's a logical progression.
Yes,
it just helps you think about
there's
all
so
these
many
things.
details in this legislation that it's very difficult to keep it all organized, and it's just helpful.
If folks wanted to have a copy of this, could you put it up in the Ops Exchange, or who could they get a hold of?
No, we can post it.
Because
I can
it's
talk
something
about
that could probably be tailored to the individual district.
Right, they could use ours as a model, and I'm sure everyone could improve on it, and we can work collectively to create something as a
Right,
group. Yeah.
right, okay.
Perfect.
Great, thank you very much. I think we have Mo Wong on the line, Chief Deputy of Information Technology from the Bankruptcy Court in New Jersey. And Mo, I understand you've developed a means testing calculator for pro se filers. Can you describe it, please?
Yes, Bob. Thank you for having me here.
You're welcome.
When we first began to study the new bankruptcy laws, one of the sections that seems to be very complex was the means test. We thought that if there was a model of the means test in the form of a calculator, it would be a great way for us to become familiar with the process, and like you said, potentially it could be used for pro se filing in the future. When we couldn't find one on the internet with the details that we were looking for, we set out to create one. So right now, what we have is an educational tool. It's also a great what-if tool. You can try out different scenarios and very quickly find out whether a particular set of parameters will result in a Chapter 13 filing. And also, since we document the source of the information we use in the calculation, it's also a handy collection of all the reference websites that we use. The current version is not completed yet, and so it cannot be used in a real case filing. For example, it's still not clear to us how mortgage payments should be treated. So when we get more clarification on issues like that, we will include them into the calculator. I think someone mentioned that before. The information about it is on the FJC Court Operation Exchange site, so if anyone is interested, you can go there. And you can also go to our website at www.njb.uscourts.gov/means test and try it out and see what you think. The program is written in Perl, so it can be very easily adapted to the other courts. Anyone who's interested in getting the program, just give me a call at 973-645-6474. Thank you, Bob.
Boy, thank you, Mo. That's a lot of information. If they don't know where to go now, I don't know. I don't know. Thank you so much. Susan, let me return to you. How are you dealing with the new filing requirements and also deficiencies?
Okay, we're just getting started, so no one should think we're ahead of the game. I think we're where everyone else is and just kind of sifting through and filtering down what's being done nationally so we can direct ourselves locally. But some of the areas that we are starting to have conversations on and need to make decisions on are things like the means test. And we've heard from various panelists that they're going to make it as less burdensome for us as possible, but there will still be issues to decide. For instance, if the debtor does come to the counter and hasn't filled out the form, that is a deficiency. The normal time frame for most petition deficiencies is 15 days. Because our notice of the presumption of abuse carries a 10-day requirement, we need a shorter time to address that particular piece of information. So courts need to decide how much time do you give for the correcting of that deficiency. We use a 2-day missing document period for the creditor matrix currently in our court, and it may be that we use that time period. I don't know, we haven't yet made that decision, but that's the type of local decision. Another example would be with the reaffirmation agreements. Those currently do not require the same amount of scrutiny that the new act will require because we need to make a decision whether undue hardship presumption arises and whether it requires a hearing. So there will need to be some review process for the information in the agreement, and whether that's done by the clerk's office or chamber staff, that needs to be decided. Another example would be the credit counseling certificate that was mentioned previously. Again, that document under the act is required at filing. If it doesn't occur at filing, there's a deficiency. Do we give it the 15 days that the other documents currently receive, or is there a shorter time period that the judges feel is appropriate? So those are the types of matters that need to be talked about and local decision made so we can set deadlines and tracking, correct. Right. And some of them may come nationally, but I think because we're not sure, there's no problem. I think it's useful to have the discussions now to start coming up with some ideas on what you would do, and then if the Rules Committee fills in those dates and timeframes, that's fine. But if they don't, we're not scrambling in October to try and fill. Absolutely. Yeah. So I think it's helpful to start discussing and coming up with solutions, and then seeing if you need to put those in place.
Great. Thank you, Susan.
You're welcome.
Val, let's turn to you. The BAs are located in the 3 districts of Alabama and the 3 districts of North Carolina, and they're performing a lot of, if not all, of the functions of the UST. Correct. So talk a little bit about how the Act impacts what you do as a customer.
Well, we have a number of new duties under the Act, and at this point what we're trying to do to follow up on what Susan said was we're trying to read the Act and learn as much as we can about it and begin to understand the various aspects of it that impact us as opposed to the clerk's offices or chambers, At this point, what we're looking at most carefully is the way that we're going to handle these things procedurally. For instance, approving or disapproving of credit counseling agencies and financial management courses. The proposal has been floated that we do an open season, if you will, each summer, and have these agencies make application to us, put the forms and whatnot on our websites, and have these companies take responsibility themselves for obtaining the information, making application within the proper time, and once we receive notice of that application, we'll take a look at it, make a determination, and give them notice back. Then, of course, we have to give notice to the clerk's office. Clerk's office has to maintain the list of approved agencies. So we're looking at how to actually go about doing that. Same with financial management training. At this point, and I think Mo touched on this a moment ago, we don't yet know the parameters of what is and is not sufficient for this financial management training. So we're having to make some decisions about that amongst ourselves. What's going to be crucial for us, and I think crucial for all the courts, is to communicate, particularly with outside customers like us, the USTs, the bankruptcy trustees, the bar. It would be helpful to us to be included in the process of planning these things out, because there are tasks that we have to undertake that will be affected by what the clerk's office does, what Chambers does. Likewise, there are tasks that we have to undertake that will affect what the clerk's offices do. So I encourage everybody to put together a plan for implementing this thing and communicating as openly as possible with all the players in it.
And the whole issue of credit counseling, the certification of credit counseling organizations is a very complicated one, because you might be talking about a different situation in a different district. And so
well, absolutely. We've got to make sure that if I have approved of agency X in my district, I need to find out whether my colleagues have disapproved of agency X in a different district. Likewise, we've got to figure out what to do if the debtor goes and obtains a certification from agency X in a completely different state, in California, in Montana, in Wyoming, wherever. If we've never heard of that particular credit counselor, is that a sufficient certification for that particular debtor? And we don't know. Likewise, we've got to figure out now what to do about those debtors who file on October 18th, for whom credit counseling will not have been available within the 180 days prior to their filing. And we're still talking about those issues and seeing what we can do about it.
Yeah, in addition to that, there's an auditing function will have to be. I'm assuming that is how do you monitor what these counseling agencies are doing to make sure that they're keeping the standards up?
Oh, absolutely. We've got to review their standards on an annual basis. That's in the Act. And again, there's a lot of subjective decisions to be made as to what is sufficient and what is not sufficient. So it's certainly a learning process for us as well as the other people in the process.
Yeah, I know the BAs sometimes, I feel, have a little bit of a leg up. I'm back in 2001. We were running workshops just covering some of these very subjects when we felt the passage, if you will, was imminent. We were talking about means testing, and we were talking about debtors' school education and so forth.
Yeah, I think it was 2001, in one of the last 5 imminent passage years. We did get together in Charlotte, and each bankruptcy administrator took a portion of the then Act and picked it apart and made presentations to the group. I know debtor education is being done in North Carolina. And we have one of our trustees doing it as well.
Yeah,
and
there's a trustee education network.
I think it's called the 10 Network. Yeah. It's sponsored by the NACTT, and that's a good source for materials.
Wealth of information, you mentioned North Carolina, and we're going to explore that a little more with John Peterson, who joins us by phone from the Bankruptcy Administrator's Office, Middle District of North Carolina. John, are you there?
I am, Bob.
Good. Welcome, welcome. I understand Middle District has a Chapter 13 debtors school.
We do. It was started back in the 70s by Judge Reynolds.
Great.
I was told it was the oldest program of its type in the nation.
Great.
We have 3 divisions and have 2 educators. The divisions share the cost, which gets us one consistent program throughout the whole district. And they use materials that are purchased from the TENS network that y'all were talking about. Mm-hmm. What we do is we have the class the morning before the 341. That way the debtor just has to come one time, doesn't have to miss another day of work. They tell me some of the big parts of the class are that they help them think about living on a budget and what that means, and help them understand the importance of the 341 meeting. The educators are able to provide information on budgeting and financial planning, plus information on the credit system, how it works, as well as budget counseling. You know, not only do we have the class that every debtor is required, but they also do special classes to teach people how to shop for a car, shop for a mortgage. The debtors can come back at any time, take the class over, and when they get ready to get out of 13, they even can come in and meet with a budget counselor and get some education on life after bankruptcy.
I might join that one, John.
Yeah, me too. A good contact for additional information is Scott Kehian, Kehiaian, and he can be reached in Greensboro at 336-378-9164.
Great. As I understand it, you've also developed a CD or something that explains a little bit more about the program?
They do.
Okay.
They actually have the course on CD. It's about 2 hours long in 2 sessions. And I'm sure Scott can tie them in to getting a copy of it.
Okay, that's a great resource for clerks if they're looking to see what kinds of programs are being offered.
Yes, sir.
So thank you very much, John, for joining us.
Thank you. Have a nice day.
Thank you. The same. I want to switch our focus now to training and education. Sean, I want to ask you a question. I know that within your district, you've done quite a bit with getting a training program going just in anticipation. Tell us a little bit about that.
Sure. Obviously, the national initiatives that we've discussed earlier in this program are going to be the driving force behind a great deal of the education that's going to be going on in the clerk's offices throughout the later part of the summer. But what I wanted to do is I wanted to focus a little bit more on ramping up to that education program later in the summer and deal with more of the bankruptcy reform basics, if you will. And I approached in a 3-tier approach to training, and the first tier was basically just each week in an informational newsletter to my staff, I'm sending out bits and pieces of the bankruptcy reform bill and a little bit of explanation and so forth, just so that those people that are working on the case administration that aren't so familiar with the possibility or the term of a patient care ombudsman or a cross-border insolvency get a little bit of a flavor of what's coming within the next couple months. The next tier is going to be panel discussions much like this one, where my IT director, my chief deputy, my deputy in charge of the divisional office, and I will be sitting down with the staff and discussing different areas each month, whether they be deadlines, noticing, reporting, or hopefully as we get closer to the rollout of the new forms, discussing some of the new filings that we're going to be seeing come October 17th. And then the final tier is probably the more challenging of all three. And I have a training team assembled to come up with some possible ways to make this a little bit more fun. We're coming up with activities and games throughout the entire summer that keeps bankruptcy reform in the forefront throughout the entire summer so people are familiar with the terms and so forth. And we're working on crossword puzzles and games and so forth just to kind of shed some light on the darker corners of the bill, basically.
Yeah. Who's actually providing the training for these sessions?
Well, through the first panel discussion, as I said, it'll be the IT director, my chief deputy, and my deputy in charge and myself. And then future classes will be determined based upon the needs of the office. If they say we should probably have this structure set up for the training, we'll come up with the curriculum, but we'll have a structure set up primarily by majority rule within the office to see what the best response would be.
That's great, and I think we've put that training plan that you have up on our resource page, so if folks want to access it, we're going to provide that website a little bit later, but that's Absolutely. A really good resource for them to look at. Thank you. Dana, let's turn to you. Do you want to comment on our national conference that we're going to be having? This in your capacity as also the chair of our Clerks Training Advisory Committee.
Well, I do want to, and I would want to encourage everybody in the audience to take a few moments to remember that in November of this year, we're going to be meeting in Seattle for our semi-annual conference. This is a conference for clerks of court, chief deputy clerks, and bankruptcy administrators. And it's obviously time to be post-implementation. So one of the things that we're going to be looking at is getting some of our time on the schedule to talk about how we've implemented it and what we can do better. So we're going to put this time in so that people can share about what they've come up with and hopefully build upon what others have done and take something back to their court and use it.
That's great. And the best thing is they will have had an opportunity to implement many of these. And it's a great vehicle for sharing. And that's what that open space part of it is all about. So thank you. Thank you, Dana. You know, there are many different approaches to information sharing, and we want to check in now with Bill Stilgebauer, the clerk from Utah. Bill, your court has a blog developed to discussing the various parts of the Act. Tell us how it was developed and who actually participates.
Sure, Bob. We have a blog, or what we call the weblog for the new bankruptcy law, and it was conceived by one of our bankruptcy judges, Judge Bolden, and it was developed by our IT staff, and it's currently maintained by just one employee in the clerk's office. Its primary purpose was to generate ideas from the local bar and other interested parties on how our local rules might be impacted by the various sections of the new law, and then to solicit feedback on possible changes to the local rules. It also allows for general comments and questions about the new law, and therefore is also sort of an interchange of ideas. Rants are forbidden by the rules of the blog, but we do have a few mild rants posted, and they do provide some reading entertainment. We've had about 80 comments posted to date.
Wow.
My IT people tell me this is a very easy installation, easy to configure and use. It's from a free open source weblog program, and we have the information posted on the court's Operation Exchange, Ed's Place, and also CourtForge. So there are various ways one can get information about the blog, and if you want to take a look at it, it's on our external website. Anyone seeking further information certainly can give me a call, and I can put you in touch with the people in my office who know a lot more about it than I do.
Thank you, Bill.
Okay.
Yeah, again, that's a great source of information, and now we're bringing in people. Bill is bringing in people from the outside, the attorneys and what have you, which leads to the next question, Dana. Sean talked a lot about internal training, but talk a little bit about external training, how important that is as well.
And I have to say it's very important to emphasize that the training is not just internal to the judiciary, but is external. There really are 4 groups that the courts need to focus their attention on. First, of course, are those members of the bar who practice before the court. We always think of them. But now in our e-world, we have limited users in CMECF, and they need to know things about what the changes are going to be. We also have bankruptcy petition preparers, and we have pro se litigants. And we are going to need to make sure that they are up to speed on what it is that they need to know so they can comply with the Act. There are several things that people can do, but when they look at those choices, they really need to decide, are they making people aware of what the new legislation is, and or are they conveying knowledge? Is this a delivery of knowledge when they're doing the training? And there's a difference. You know, when you're doing an awareness training, you just want to make sure people know what's new. But when you're talking about delivering knowledge, you're talking about how to. How can the person who is seated in the audience know what to do and comply? And let me give you a couple examples of that. If you were talking about awareness training, I would suggest that somebody would want to first look for a few moments at newsletters. A lot of courts employ newsletters in the traditional sense. They also employ them in the electronic sense, where they use the CMECF addresses, email addresses, and then they send those email notices out or letters out to everybody. And that's a great way to leverage what we have automation-wise. Another opportunity is to use a court's website. Many of us are operating websites that have just chock full of information, and this is another avenue to place that information on the website. Those really are more awareness-oriented techniques, but if somebody was looking for a delivery of knowledge technique, you know, they might want to look at traditional CMECF training. How are they going to update their curriculum so that they can make sure that they have incorporated what's new in this legislation? They also might want to look at their CMECF admin procedures, and perhaps they're going to have a standalone document that's going to be on this new legislation. How are they going to convey that information to people? How are they going to train them on what they need to do so that they can be in compliance with what the court expects? And of course, you know, it's very important sometimes to have face-to-face meetings. And so a court might want to consider doing something informally, such as brown bag lunches, having those conducted on a regular basis, maybe suggesting a particular topic. Or they might want to do something more formal. Perhaps they could do some type of a half-day or a full-day seminar, either putting it on themselves or doing it in conjunction with a local or a state bar association. Yeah. But all of those are ways you could convey knowledge to people.
All right. Thank you, Dana. Thank you. We also have Yvonne Evans via the phone. Yvonne is the clerk of the Northern District of Georgia. Hi, Yvonne. Are you there?
Hello there.
Welcome, welcome. Yvonne, we hear your judges as well as staff are taking a very active role in taking steps in order to better familiarize themselves with the requirements of the Act. So describe what's happening in Northern Georgia.
Before I get to that, Bob, I'd like to say greetings from the home of America's newest rainforest in Atlanta and the entire Northern District of Georgia. Both the judges and the clerk's office management staff have taken an impressively aggressive approach to our preparations for the new law. Chief Judge Bahari and I adopted the divide and conquer strategy that has worked so well for this court during past big projects, such as the implementation of CMECF. The 8 judges of the court agreed to each take a part of the new law and become an expert on the legal implications of his or her assigned chapter and or sections of Title 11 and Title 28. The judges also agreed to each share their wealth of knowledge by presenting a 2-hour training session to each other, their law clerks, and invited clerk's office staff. Likewise, the clerk's office implementation team members have divided the new law into 8 parts, with each part assigned to a team member who will become an expert on the procedural implications excuse me, Bob, of his or her part, including such topics as the new filing requirement, the means test, tax returns, noticing, deadlines, docket events, etc. With the view of sharing this information with all staff, each team member will study the amendments to Title 11 and list out the impact those amendments will have on the clerk's office, the judges and chamber staff, the attorneys, the U.S. trustee and case trustees, and the public, including pro se debtors. We thank the AO and the FJC for the 2 scheduled FJTM broadcasts regarding the new law, including the one today and then the one on June 29th for the judges. We will participate in both live broadcasts and will record those sessions so that we may share them with all staff in future scheduled sessions. Today's broadcast will be replayed 9 times for the judges and staff, and the June 29 session will be replayed 8 times. Everyone has access to the JNet and will be able to review the BCAD webpage dedicated to the new law. We're excited about the academic challenges and significant changes that will result from the implementation of the new law. But as with everything, attitude and presentation are everything. Both are what we do best here at the Northern District of Georgia. Thank you.
Thank you so much, Yvonne, for your comments. We appreciate that. Let's take a few minutes now to respond to some of the faxes that we received. I don't know if you've seen, this list has been growing. We've had some very active listeners, so I want to ask that some of our panel members respond to this. Here's one that came from Paul Martin, the Eastern District of Texas. In those Chapter 7 cases where a debtor has applied for informa pauperis relief, how will courts process payments for attorneys who have filed electronically a case with a pending informa pauperis relief request and then go on to electronically file other cases where the file will be collected? CMECF requires payment for all in full. There's no option to pay anything but the filing fee in pending informa pauperis cases. Who wants to tackle that?
Well, I'll take that one, Bob. We are looking at that in CMECF, and what we are doing as far as informa pauperis goes is we're trying to make sure that the computer program is set up to recognize those informa pauperis applications, and that at that window of time it would be a zero balance for that case. And when a party like the attorney is batch filing a number of different cases that have filing fees due, this would zero out as to the one case or whatever number of cases the person has for informa pauperis, and then the attorney would pay whatever the amount would be due minus that one case. And then if indeed the record reflects later that the judge decided not to grant informa pauperis, the fee will become due and owing, and that point then that comes down to a local procedure on how that's going to be handled by that court.
Great. We have another fax here from Judge Cornish and Teresa Buthard from the Clerk of Court, and that is in Oklahoma. Eastern District of Oklahoma. And Jim Waldron, I'm going to direct this to you. Is it anticipated that requirements to file under IFP will be made nationwide or by individual courts? For instance, will it be necessary that the debtor be pro se? How will the trustees be paid when debtors are approved to file IFP?
Bob, you told me that maybe I could phone a friend if I didn't know the answer. I refer that to Barry Lander, my good friend, who gave me that advice also. I have to tell you that the Rules Committee discussed that, but has only discussed it briefly, and the parameters for how that's going to be handled are really not clear yet. So I don't think that I can give an answer. I'm sorry about that. But I'm sure that we will have another discussion about that next week, and we'll be getting that kind of information out shortly.
Great. Thank you. Here's a question on tax returns. If it is contemplated that tax returns will be imaged and saved as private docket events in CMECF, will clerks be permitted to destroy such hard copies of the tax returns once imaged, and will a party of interest or trustee's request to view them be limited to the clerk's office public area? Who would like to?
Well, I might be able to help you a little bit on that one. As far as what the court will do with the image documents, that may come out of the Reform Working Group as a suggested practice. And of course, local courts do need to come up with what their practices are going to be, because what will come out of the working group are suggestions as opposed to mandates on how things will be done. Mm-hmm. And your second question about that had to do with the CMECF component, and perhaps you can refresh what that was. Oh, access.
Access to the files.
Right now, we're not looking at using tax filings as private events in the way that everybody in the court family thinks about them. We're talking about actually using something called restricted access. And those are events that case participants who have CMECF login and passwords would have access to. And so they wouldn't necessarily, the trustee, have to come to the court's front counter to see this tax filing. But because they have a login and password they could see in this case, they would have restricted access. But it's not the type of access you get through PACER. So somebody going in PACER would not be able to see what a person who has restricted access would be able to have. So it's a different level. Mm-hmm. It's just not something we've been using in CMECF widely, and we want to explore that to see how well we can use it with tax filings.
Thanks, Dana. I should mention to folks that these faxes are starting now to pour in, so if we do not get to your fax, we'll make sure and provide you an answer later on, either through the Court Operations Exchange or some other vehicle, but we only have time for just a few more. Val, there's a question here from Jan Smith from the Southern District of Alabama. Who will be conducting the financial training for the debtors? Do you know that?
At this point, what we understand is that financial training can be provided by private entities, much the same as credit counseling will be provided. It is up to the BA and or the UST to approve or disapprove of the providers of that training and the content of the training, much in the same way that we will be handling the certification of the credit counseling agencies. Again, we're in discussions about all of this and coming up with the framework for handling that and the framework for making the substantive decisions about what is or is not sufficient for these folks. You know, is a face-to-face necessary? Can it be 20 minutes over the internet, or does it have to be every Saturday for the next 3 months? We've heard some great suggestions, particularly from John Peterson, about what's done up in North Carolina. I know one of my trustees in Tuscaloosa also has debtor education, and it's showing great returns. The debtors are actually walking out of there with a clue as to what to do after bankruptcy, and that is, of course, the whole point. So it is a positive thing, but as far as I know from my reading of the Act, it is our responsibility to certify the financial management training that's available from a variety of sources. And I know I get calls every single day now from people who want to set up these companies and provide this service. So that's how it'll be handled.
Great. Thank you, Val. We're going to take one more fax. We just literally have a few minutes before the end of the show and the closing. But let's take this from Karen Eddy, the clerk of the Southern District of Florida. Please clarify the statement that the attorney will check off a box to designate presumption of abuse on his or her own case being filed. Jim, can you handle that?
Sure. Again, these are preliminary discussions, and we don't have the form worked out completely yet. But the way that the form has been coming to the committee so far is that there's been a working group, a kind of a sub working group between the United States Trustee's Office and the chair of the subcommittee. And what they have been discussing is basically the form, which shows all of the calculations, but finally there would be something at the top of the form which would indicate whether or not there was an abuse. And that was something that people discussed quite a bit. Again, we will see if the entire committee agrees on that, but right now that is just a discussion at the subcommittee level, but it seems to be that that's the way it's going to go.
Thanks, Jim. And again, we're going to address whichever faxes we didn't get to, we're going to address a little later on, either through the court operations exchange or some other vehicles. So your questions will be answered. What I would like to do is go around and just kind of get your feelings. What's some good summer advice, if you will, for what do you think clerks ought to be doing now, clerks and BAs? Susan.
I would suggest that clerks and deputy clerks attend our 2005 annual conference of the NCBC in Chicago, which is the week of July 4th. We do have a panel scheduled with several judges and clerks to address the bankruptcy legislation and procedures. So I would encourage people, there's still time to sign up. And I would also suggest that when you come, bring what you have done so we can share the information. There's also going to be some then breakout group discussions, and to the extent any of us have come up with some suggested solutions, it's, you know, this is a team effort. And if we could share those, we can all help each other.
Great. Val.
Bob, I think I want everybody to remember that none of this is hard. It is complicated, it is complex, but it's not hard. And as long as we are sharing information, if you're going to be changing your CMECF dictionary events, share that with the UST, share that with the BA, so that we can change our systems as well. If you're going to be implementing new procedures, talk to each other, because everything that you do affects us, everything that we do affects you. And I think that that we'll be in good shape.
Hard work, but communication is absolutely key. Dana.
I would suggest people consider the CMECF Operational Practices Forum in August, and including those people who are able to come in person, but also doing a remote opportunity to participate and really take advantage of it.
Yeah, and that's a great opportunity because
we can leverage the automation so that everybody can participate across the court lines.
Yeah. Sean, I'm giving you the last word.
Outstanding. Just familiarize yourself with the bill. I mean, go through the entire act and make sure that you understand some of the provisions and some of the impacts. But most of all, there are a lot of resources out there right now. The clerks have been doing a lot of analysis, and a lot of it is posted on the Court Operations Exchange. And so my suggestion would be to take what you can from the Ops Exchange, but also to contribute, because we need as many different perspectives on this as possible so that we've got a well-rounded knowledge base when we approach October 17th.
Thank you. And that's a good segue, because we really want to talk a little bit about additional information, but we're just about out of time, and I want to thank our panelists and for our listeners who faxed in all of these faxes. What I'd like to do is to provide you with a list of upcoming programs devoted to keeping the discussion going. We have a series of audio conferences scheduled with many of the faculty from today's program. On June 15th, there's going to be a discussion on the rules. On June 21st, like in this panel, like in the panel previous to this, the focus will be on CMECF. And on June 27th, the audio conference will address local initiatives. And you'll be able to ask questions, get the latest information. So to learn more about these audio conferences, go to the website that's going to be shown on the screen momentarily. Then on June 29th, there'll be another FJTN broadcast. And this one's for judges, law clerks, and staff attorneys. And the focus is going to be on questions that judges are likely to face. It's going to feature two specific components, business and consumer issues. Today, our panelists noted several information sources to help you become more aware of how their implementation is progressing. First, remember the CMECF Working Group has a website you can access at this URL that's presently being posted. Secondly, both Robbie and Dana mentioned the Bankruptcy Court Operational Practices Forum scheduled for August 18th and 19th. And we should note that more information will be forthcoming about participating simultaneously, as they mentioned, in the audio conferences and WebEx presentations. Third, we have our FJC resource catalog at the address being posted. There you'll find suggested readings dealing specifically with the Act. And fourth, to continue to study the impact of the Act on the clerk's office, we really want to encourage you to visit our Court Operations Exchange at the FJC intranet site. We've mentioned that a number of times. There you can ask questions, share comments, obtain resources, contribute new items including revised rules, procedures, implementation strategies, and so forth. Also, BCAD has a website worth checking out. Mary made reference to it. Finally, we've included an evaluation form as part of our downloadable materials. We would very much appreciate your comments and suggestions regarding specific additional activities that we might provide to help you know more about what's happening in the Act. We hope this broadcast has been interesting for you and given you some valuable advice. Thanks again for joining us, and we'll see you on our next FJTN broadcast.